there must be memorandum in writing and an execution by parties for you to say that conveyancing has taken place. Provisions of law regarding real estate. It was created to regulate the transactions, relationship of people, to ensure that everything is compliant. We have primarily our sources of law from the customary law, and the customary law provides that where there is witnesses to the transaction and there is a receipt and then there are witnesses, it suffices that there has been interest. There's conveyancing from one person to the other. We have the case laws. These are where disputes and arising out of property transactions, and the courts decided on it. The Superior Court, in this regard, the Supreme Court, any decision taken binds and acts as a we call it stare decisis. From any other lower courts that are deciding will be based their principles on the principles of that higher court to guide subsequent registration, subsequent transactions in that regard. We have the received English laws, the statutes, the statute of fraud, we have the equity, and what this tends to do is, if there is perchance we don't have any laws or any similar principles, local one established, in the event there is dispute, this received English laws, the principles will guide that transaction. We have the direct Nigerian legislations. The first one is our constitution. Section 43 gives every citizen of Nigeria the opportunity to own immovable property in Nigeria. And we have our Land Use Act. Our Land Use Act vests the property in the hand of the governor to hold in trust for any member of the state. We have the PCL. The PCL regulates the laws in Oyo, Ogun, Ondo, Ekiti, and some part of Lagos. The PCL is Property Conveyancing Law. So what this means is that the main section of the law means if there is any property transaction, there must be a memorandum of understanding, memorandum in writing, and an execution by parties for you to say that conveyancing has taken place. The Legal Practitioners Act that makes it mandatory for lawyers to be the one to prepare documents. Unfortunately, we have these days, you see people, estate agents preparing tenancy agreements and all that. It should not be so. The LPA makes it mandatory for lawyers to prepare any legal document regarding any transaction. The ILLITERATE Act. The ILLITERATE Act, the main section of it regarding real estate is that if by any means there is any illiterate involved in a property transaction, the content of that document must be read and interpreted to the person to be able to understand before appending the signature. In event there is any dispute and it's discovered that the content was not read to the person, it renders that transaction null and void. We have the Administration of Estate Act. The Administration of Estate Law, what it intends to do is that it regulates the administration of estates, whether when someone dies in estate or where there is appointment of trustees to manage the property of the deceased. So the interest, the rights, and everything is contained on how it should be done. Who are going to be the representatives of the family to be able to transfer valid title to whoever the probate court wishes. We also have land preparation instruments. I think the first one was in Kaduna. What it provides that a lawyer must prepare is also similar to the PCL, the LPA. A lawyer must prepare documents relating to property transaction. Land registration laws. Lagos, this is what regulates Lagos and some other states in Nigeria. the Mortgage Act, when it comes to the, when I say act because it has to do with the federal capital, and laws when it has to do with states. So all these are policies that have been put in place. Recently, last week, we were in the stakeholders meeting with the SA and the IG of Lagos with some lawyers in real estate practice, because a law was passed, enacted, a bill was passed into law by the governor sometime in February. Is Lagos State real estate regulation laws. What it tends to do is to regulate real estate transactions in the state, and I believe Oyo State can adopt that, because it's a good way to regulate the real estate transactions. It means what the law is trying to do with that last railer is that for you to be a real estate professional, you must register with them. The law calls them the authority. You must register with them. You will obtain a permit, and that permit is renewable every 1 year. For you to be, if you're a real estate developer and you are, people subscribe, probably you have a land measuring like 10 plots, and then you oversubscribe to people 200 plots, it's fraud. So it operates to checkmate the activities of developers in the state and also other real estate professionals in the state. And these are many more laws that are regulating real estate transactions depending on the state. Thank you.
Thank you.